Hi everyone, it's me Jenisha Gautam. I'm going to give a short presentation on the topic contract law. We have done one case, and I'm going to talk about the issue and rule of that case. First of all, the issues are: does Sue Burgers have a valid contract with Mickey and Brent separately? And the next one is: if Sue Burgers have valid contract with either of the two, what will be the implications to them of the said contract? Now we are moving on to the rules. There are for the rules to be valid, the contract to be valid, there should be the three elements of contract should be present in that contract. On that case, the three elements of contract are agreement between the offerer and offeree, and intention to make an enforceable valid obligation and consideration. Agreement can be recognized when an offer and acceptance is present. A valid offer must have the following: willingness and intention to be bound, or strong promise, communicating of offer. Invitation to treat cannot be considered an offer. Rather, it is the starting point of making an offer. The person who respond and reply to the invitation will make the invitation to treat an offer. An offer can be available to the world, where anyone who is conscious about it will accept the offer by fulfilling the terms of it. One of the ways to terminate an offer is by revocation, wherein the offeree must be aware of the extraction and withdrawal before any acceptance can take place. Acceptance translates the promise in the offer into agreement, making both parties, offerer and offeree, bound to the agreement. If this is a simple contract, then it is important to assess the validity of the contract, and additional elements must be considered, such as legal capacity, consent, legality of purpose, and form of the contract. Without real consent, contract will, with the three main elements, may still fail. One of the obstacles to genuine consent is entering into a contract and realizing that there was a mistake to the contract. If the mistake is present, one probable consequence was to bring the whole contract null and void from the start. This is called void ab initio, which placed the parties in the similar position as if there was no contract ever made. One kind of mistake in the consent is non est factum, which is a mistake as to the nature of document, and this mistake make the contract void. The success of the non est factum lies on two factors. The document or detail of contract is completely different from what is agreed, and there was an absence of carelessness and negligence in the implementation. The party raising this defense have a great responsibility to prove that the case has the balance of probabilities. Thank you. Now I'll call Jaljala for the further presentation.
Hello everyone, it's me Jaljala Khadka. I'm going to present my part, that is application and recommendation. So burger competition is deemed to be an invitation to trade, but upon the response of by Mickey, the invitation to trade becomes a contract with all elements to contract being present. The offer made by So Burgers to the world was valid offer, as there was intention to the words and conduct, and because So Burgers was promising to give Mazda CX-9 to anyone who will abide with all the rules of their competition. As to acceptance, Mickey exerted a lot of effort to the point that he was sent to hospital performing the act on the contract to avail the scratch card and winning the grand prize, and thus this is considered as acceptance by the offeree. Although So Burgers terminated their offer by revocation, the communication already happened after the acceptance took place, as Mickey already exerted too much effort in order to fulfill the conditions of the agreement. So Burgers' defense in Mickey's case is that the contract is void ab initio, making the contract null and void from the beginning, as there was a mistake on the nature of the document. As per the case, the mistake was on printing the incorrect golden ticket. For So Burgers to succeed on non-est factum, they should establish that they act very carefully without being negligent, sending tickets to their stores without checking how many tickets have golden card is a sign that they are not prudent on their actions. Same application of the law is available for bread vulture, but this is without regard as to what method he obtained his ticket, as it was not stated in the case what method it should be obtained. On the other hand, it is clearly stated in the contract that the golden ticket with golden card present by So Burgers customer will win the Mazda CX-9, as Brett only collect his token by scavenging discarded wrappers outside the fast food chain. Now I'm turned onto recommendation. Is all elements on that contract between Sue Burgos and Mickey are present. Sue Burgos is liable to give to Mickey the Mazda CX-9 as contract, and especially that Sue Burgos gave away the price to one of the customers who came in first at their head office, as there was no clear instructions as to the duration of the competition, whether it is over after the first contestant presented his golden ticket. Mickey act in the scope of the contract, and with that Sue Burgos should be liable either to give the consideration with the contract being valid. So Burgos is liable to any damage or to give the consideration in the contract. As to Brett, Sue Burgos is not liable to him as he is not a customer of Sue Burgos at the time that he participated on the competition. Thank you. It's all about part 1.
Hi, my name is Jenny, and together with my friend Diwa, we will discuss Part B Corporation Law Option 1. So I will discuss the issues and the rules. So in issues, we have several issues. Number 1, is there any agency relationship between Sparkling and Sarah? Number 2, does Sparkling have the right to stop the payment of the loan? And does Castello Bank have the right to go after Sparkling or Sarah? And the last one is, will there be a different outcome if the loan made by Sarah is for refurbishment of the 2 factories of the company? And now I'm going to the rules. With the rules, we're going to discuss agency. Agency is an exception of the doctrine of privity of contract. The principal in agency grants their contractual capacity to the agent with the basis of their agreement. Agents should act in due care. They need to operate in good faith, having the principal's interest on top of their transactions without any conflict of their personal interest. Agents can be appointed in 4 types. It can be express, implied, operation of law, and by ratification. In appointment by ratification, the principal and the third party contracts are not binding unless the principal ratifies the contract. Ratification can create rights and liabilities to either principal, agent, depending on the act of ratification. This may release the agent from any obligation or the third party from contravention of warranty of the authority, and the third party can change the principal and the vice versa as if the agent's action was approved by the principal. And the third party, even strangers, should be aware of the ratification. They should be notified by the principal or by the agent. Now we're going to my friend Diwa.
Hello, my name is Diwa, and I'm here to present application and conclusion of my part. In the problem, the Sarah is an agent of Sparkling Private Limited for only 2 years as expressly stated on their contract of agreement. After the expiration of her contract, she continued to be the agent of managing director of Sparkling, even though there was no lodgement of a renewal of her contract. The retention of her position is an implied action of Sparkling, acknowledging that she's still their agent. There was no termination of her agency agreement, as there were no termination happened. The bank, as the third party in the problem, was unaware, and they transacted with Sarah in behalf of Sparkling. Upon knowing about the loan, immediately stopped the payment of the loan. The bank sued Sparkling in this matter as they were unaware of the fact. Sarah restriction as an agent and expiration of the contract. In return, Sparkling now can go after the Sarah for breach of contract of agency. The case would be different if the loan was for the interest of the company, say for the instance for refurbishment of 2 of Sparkling clothing shop. In this case, the money loaded will all go to the project of Sparkling, and although she acted beyond the $20,000 limit as she borrowed $30,000 from the bank, this is still for the company best interest. I'm heading towards conclusion. Costello Bank can also ask Sparkling for payment, as although Sarah's contract as the agent was not renewed, her appointment was an implied appointment. Also, Costello Bank is unaware of the limit on the agency contract between Sparkling and Sarah. If Sarah acted in a good faith and with the best interest of Sparkling, then there would be no reason for Sparkling not to pay the loan otherwise if Sarah acted in a bad faith and with the wrong intentions. Then Sparkling can go to court to sue Sarah. Going to the court and suing Sarah will then end the agency relationship that they have. Thank you.